Hello and welcome to a special section on case briefing. As I probably mentioned in the video, we're not going to be doing a lot of case briefing in this class. However, I am exposing you to a number of cases during the course of this semester. So if you want to start briefing cases like a lawyer would, it might help you in learning some of this law. It's not a skill you really need to master to do well in this program, but it will give you an idea of the type of work a lawyer does, and it might help you to clarify what a court is doing when it determines a case, and of course when it issues its opinion. So in your text, there is a case, Commonwealth versus Cato. It is slightly edited, and I will show you bits of the original case as well. One of the main things that a lawyer does when looking at a case is to determine what the issue in the case is. And there's often many issues. Now you may remember in your reading about statutes on page 21, reading statutes, it talks about the process you should go through when you're reading statutes. Ask yourself, why are you reading this statute? It will give you a good idea to find out what it is you're looking for. And of course, you should read it carefully and question the context. If there's a law that says, for instance, that children should not be smoking cigarettes, you should look at it in the context of, is it a public health type of law? Are you looking to see that we don't want children smoking because we're afraid they will get sick? Or is it something about, as smoking laws were in the old days, something about morals or even about fire safety? You want to make sure that you're reading the correct statute. If it's just about children with cigarettes, make sure it matches with what you're looking up. And then you want to evaluate the law. Are there ambiguities? And in the sample that they give you in reading statutes in your text, we have this issue as to whether or not someone is breaking and entering when they don't physically enter someone's property. Next, you've got to find out if there are cases where a court has determined what we do with these ambiguities. Like in the case where someone throws something into a property, is that considered breaking and entering? We look at cases. So it's always a good idea to start with any applicable statutes, and then you look to see how a case has determined whether the ambiguity you found is included in the breadth of the statute, or perhaps even the scope of the statute. So here is the sample case that's in your textbook. In most textbooks, authors provide edited versions of cases. They take out stuff that might be confusing to the reader, especially a novice reader. Here is an actual full case. It's got a lot of other stuff in it. The notable thing at the beginning, we see these numbered, what we call head notes. And they're part of a research package from the publisher to help lawyers find particular issues. They can be helpful, but to someone starting out, I suggest avoiding them at first. If you're planning to become a U.S. lawyer, we can talk more about how to use them, but the electronic system of searching has kind of supplanted that system. Here is the sample brief that is also included in your text, and it shows the various parts that the authors included. And they have some really good hints as well. Like, for instance, when you're doing a brief, leave a lot of space, wide margins so you can take notes during class or when you're reading other things. And then it shows you the different parts, the style, which is just a citation, and the legal issue. You want to identify the legal issue. Now, in this case here, it's all about whether or not they are actually entering an apartment by throwing something through the window. That's the legal issue the court has to struggle with. And so your job is to read the full case and to determine these different categories. Here is a little restatement of the important facts. What are the facts that allowed the court to make that decision? It helps you understand it as well. So we have little notes here about the analysis, what the court uses to make its reasoning. So when you're starting to make your own case brief, the authors of your book remind us to skim the whole case first. When you're reading a case, it can be fairly cryptic, so you want to really organize your thoughts about what's going on in there. So your authors suggest reading through it quickly once, and to try to, think about these things while you're doing it. Try to remember, why is it you're reading the case? What is it you want to get out of it? And of course, if you're taking a class like this one, this particular case, you're reading it to see how to brief a case. But sometimes it might be to understand contract law better or something else. Then it reminds you to see who the parties are. Who's suing who? Is it the government pursuing a criminal case against a defendant? Why are they doing what they're doing? Why is someone suing or prosecuting someone? And who won? And then finally, try to just get a sense of why did they win. And then you've got the right mindset for actually briefing a case. And when you're briefing a case, remember, there's no one correct method, but the book method is pretty darn good. So I would start out with that. And again, these are really important tools for lawyers and for non-lawyers to really understand the legal process. I'm going to give you a bunch of cases during this semester, so why not try your hand at these so you can better understand not only the law, but where it comes from and how lawyers deal with the law in the United States, of course. So the first thing you put in your case brief is called the style. Actually, I don't call it that. I just call it the heading. But your book calls it the style. That's where we have, the name of the case, what court it's in, the dates, things like that. Kind of like a title. Now, it's not always the first thing after that, but the issue is very, very important. The issue is the legal question that the courts are trying to reach here. What is the legal question? For our sample case here, we know the issue is about whether or not someone is breaking into a house when you throw something through the window here. So defining the legal issue is very important. That's what the court is going to be ruling upon. The procedural history tells us how the case got to this court. Whenever we see a case written up, more often than not, it's in an appeals court. So something happened at a court below that someone has complained of. They have appealed the ruling as some sort of an error. That's likely how the case gets to be in the appeals court. For instance, there's something called summary judgment. So let's say a court in the trial below said, it doesn't matter if everything you said was true, you don't have a case. I'm going to hold for one of the parties without even putting this to a jury, without even, going forward with the case. And sometimes that's the right thing to do, and sometimes it can be error. So if indeed it was error, then the appeals court will say, well, summary judgment was not appropriate, perhaps because there were facts in dispute that a jury should have sorted out. So the procedural history tells us how it got there and what it is the court is trying to figure out. Because sometimes it's a very thin, very slight ruling. It doesn't really have broad appeals. It might just say, broad consequences. So if the court below said this case shouldn't go to trial, and this court says it should, well, then it just means that one party now gets a trial and not that someone won. On the other hand, procedural history is also important because it could say the wrong person won, and this court said that is correct, and so that it's upheld, or they say, actually the wrong person won, and they overturn the court below. So procedural history is important. The facts of the case, well, you could just write the facts over from the regular case. But remember, these are called briefs. So we want to just distill the most important parts. So when we're talking about the facts for a brief, we're just going to put in the facts that are critical to the ruling. So we call these material facts. But they're just facts that say enough about the case to show that the rule applied here and the holding that the analysis the court used, we need these facts to show the limit of the court's ruling. Let me give you an example, kind of silly, but imagine it's just after the Civil War in the United States, and Abraham Lincoln has gone to Ford's Theater to see a play. And then suddenly a man crept into the theater, and he walked up 41 stairs and tiptoed in his brown leather boots to the door that was painted red, white, and blue that held the president's box seats. He opened the door slowly to make no noise and to not alert anybody to his presence. He pulled out of his pocket a mother-of-pearl handled Derringer pistol and cocked the lever and shot the president twice in the head. Now, You could put all those facts if you were trying to charge John Wilkes Booth with murder, but the important things for murder was that he intended to shoot the president. So we wouldn't need to know about the 40-something steps. We don't need to know what color his boots are. We don't need to know, him tiptoeing. What we need are the facts that show that he indeed has murdered someone. So same thing with any kind of a case. A lot of facts in there are not necessary for your brief. Now the rule is the rule of law. The issue, of course, is the question the court's asking, but then the rule of law is, what is the rule about this? Does a person is a person breaking into a place by throwing something through the window? And then we can put, what is the rule? And of course, I want you to put that rule into your own brief. And then the holding is applying that rule to the facts of the case. Based upon this rule, we hold for the defendant, or we hold for the prosecution. And the court's reasoning is their explanation of why that is the correct rule and holding. And if you'll notice in your book, it breaks it down quite a bit about the court's reasoning, the different types of reasoning a court can use. And I should mention too, they sometimes, of course, mix these up. Deductive reasoning, inductive reasoning, analogical, and for our legal realists, modernism and postmodernism, where they say that we have to think about more than just strict deductive or analogical reasoning, and think about economic implications, policy kind of considerations. And then a postmodernist is described by your authors as rejecting a lot of these ideas because they don't provide justice to diverse populations. So they use a more inclusive type of reasoning to reach their answer. It doesn't matter which type of reasoning they use, just that you can follow why the court did what they did, why they came up with the decision they did, what kind of reasoning they use, what were their decisions. And why is this important? Well, if you know why a court did what it did, and you have another case coming up to that court, then you have a kind of an inside look at the way the court will reason through this kind of a new case. And so that's how our common law does indeed grow, by taking the law and applying it to new situations. If the reasoning is sound and the reasoning and the rule fits the new set of circumstances, then it's maybe predictable how the court will rule in new cases. Sometimes the reasoning is not as clear, or the situation is so new that it's hard to tell, but that's the idea anyway. So remember, no one correct method of making briefs. If you are an MJUR student, I don't expect you to spend too much time on them. I want you to, spend a little time on it to get an idea what the cases mean in our course here, of course, and to get an idea what lawyers do with them. So non-lawyers, don't spend as much time with it. You lawyers from other countries, especially if you want to practice law in the United States, I would spend more time with it. And if you're having any trouble at all with your case briefing, it's better to do the hard work right now and learn to do it early. So don't hesitate to contact me via email, or if you want to speak on the phone, just tell me some times that would be good for you. And if you're going to be taking a legal writing course, you will get more of this. So if your curriculum includes a legal writing course, they are experts at this as well. But why not get a head start, I say?